Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Coming to you from Washington's premier indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. Hey, for those of you who geek out on the channel all the time, first of all, thank you very much. Secondly, you know, I've been really critical of the state of Illinois lately because, well, candidly, I don't think there's any more of an evil state government anywhere in the United States than the state of Illinois. I don't think there's any state government that absolutely hates its citizens more than the state of Illinois. And I candidly don't think there's any government that's more corrupt anywhere in the United States than the state of Illinois. But about the only thing that equals the evilness that comes from the state of Illinois is, in fact, the arrogance that comes from it also. And I'm going to give you examples today. One, how they're evil, and two, how they're arrogant, and three, how this affects every lawful and responsible gun-owning Illinois resident. So today, let's spend a few minutes and let's talk about the evil and arrogant state that hates its citizens. Okay, talking about Illinois again, we're going to talk about two issues. It's not going to be how many of you are registering your firearms, because we all know the answer, and the answer is a whole lot of none of you. What we're going to actually talk about is two things. First one we're going to talk about is Caulkins v. Pritzker. Now, as we know, there was a motion to the United States Supreme Court to Justice Coney Barrett to have her intervene. And last week we got word that Justice Coney Barrett had in fact ordered briefing from all parties so that she could circulate that to the other justices to see if, in fact, the United States Supreme Court should accept review of this case. Now, a docket entry that we discovered today shows us that the state of Illinois has notified the United States Supreme Court that they will not be filing any briefing. So even though a United States Supreme Court justice has ordered the state of Illinois to do that, and even though it is their duty to stand up and support the constitutionality of a law that they believe is going to save lives, and it's so important, they need this law. This law was so important it had to be passed instantly. Well, it appears that they will not even bother to file a brief with the United States Supreme Court. And let us remember that the briefing, any party at this point who needed to file a brief, man, it's cutting and pasting from the other 5,000 pages of briefing that's already been done. So this begins to show just the absolute arrogance of the state of Illinois and how they don't even believe that the rules apply to them at any point. And that's a good segue for the other thing I want to talk about, which is a little bit of information about the Freedom of Information Act. You see, the Freedom of Information Act is an amazing piece of legislation which provides Americans with transparency in government. What it basically means is that you as a citizen, as a concerned citizen, are entitled to just about any type of governmental information, communications, or anything like that, so that you can actually assess how your tax dollars are being spent to run your government. And this involves both state, federal, and local governments. The case we're going to talk about today is the case of Hart versus Illinois State Police. It is a recently published opinion from the Illinois State Supreme Court. Now, Ms. Hart and another co-plaintiff applied for Illinois' FOID card, Firearms Owner Identification Cards, which in and of itself is subject to considerable constitutional scrutiny because we have already seen other pre-purchasing licensing requirements be struck down in recent weeks around the country. That being said, both Ms. Hart and her co-plaintiff were denied FOID cards. That is, they applied, they went through a background check to get permission before they could go through a background check to purchase a firearm. They never made it through their first background check. For some reason, the Illinois State Police denied their application. Now, both Ms. Hart and the co-plaintiff, well, they kind of wanted to know why. Why was I denied? I don't believe there's any reason that I should be denied. And they actually just made requests and were told that piss off, essentially. We're not going to give you the information that we relied upon. So then they filed Freedom of Information requests. Sometimes they're called public disclosure requests, okay? Now, every government has their own way of dealing with it, and there's certain time limits and there's certain penalties for if they don't comply or don't comply within the time limits. And I didn't do too much geeking out to understand exactly how the Illinois Freedom of Information Act works, but here's how it doesn't work. It doesn't work for somebody like Ms. Hart because the Illinois State Supreme Court has ruled that she has no right to this information under the Freedom of Information Act. They essentially have told Miss Hart and her co-plaintiff here to piss off. Now, I want you to understand just how disingenuous this ruling is, because the section of the Illinois Freedom of Information Act, which is subject here, precludes dissemination of information pertaining to names and information of people who have applied for or received firearm owners identification cards under the Firearm Owners Identification Card Act, or applied for or received a concealed carry license under the Firearm Concealed Carry Act, unless otherwise authorized by the Firearm Concealed Carry Act, and databases under the Firearm Concealed Carry Act, records of the Concealed Carry Licensing Review Board under the Firearm Concealed Carry Act, and law enforcement agency objections under the Firearm Concealed Carry Act. What it really is a roundabout way of Illinois saying, hey, listen, when we pass this law, we put a provision in there that we would not then give this information out to other agencies or other entities so that they could create gun databases or invade the privacy of those that had actually applied. And one of the lower courts that reviewed this suit and actually found in favor of Miss Hart said, well, of course, that applies to other people giving out her information to other third parties. It doesn't apply to her receiving her own information, right? I mean, the lower court specifically found common sense compels the same result. According to the court, what the legislature intended was to prevent dissemination to or by third parties of the names and personal information on FOID applicants, and not the release of an applicant's application or the ISP's denial of the applicant's application. A contrary interpretation would create an absurd result. Based on this conclusion, the trial court ordered ISP to produce Hart's application for a FOID card and a copy of the letter previously sent by ISP in which it notified Hart that it was revoking her FOID card. So what the Illinois State Police Department came in and argued is that, hey, listen, the one way to read this statute is that we cannot provide this information to anybody, including the applicant themselves, even though, yeah, we understand it is their own information. And this is how the Illinois State Supreme Court ruled. ISP contends the appellate court erred in its interpretation of Section 7.5v. According to ISP, Section 7.5v is a blanket exemption prohibiting the disclosure of all FOID card information under FOIA, and there is no exception for individuals who are seeking their own information. We agree. And I won't bore you with all of the reasons why in the statutory interpretation, but ultimately the court said, hey, there's probably other ways that you could dig up this information. So we agree with the Illinois State Police. They are under no duty to provide you with any of the information that you provided or any of the information they relied upon in either denying you a FOID card or revoking a FOID card. Now, there were 7 justices who ruled in favor of the Illinois State Police, including Justices O'Brien and Roquefort. Who would have ever thought? That case, once again, is Hart versus Illinois State Police. We will link it up down below. What you are seeing from the state of Illinois, their absolute arrogance in just telling the Supreme Court, nah, we're not going to file a brief. And their absolute hatred towards Miss Hart and her co-plaintiff, which basically says, you know what, you're not entitled to any of the data or information that we use to make a judgment about you. Folks, there is no state in the country that hates its citizens any more than the state of Illinois. There is no state in the country right now that is more sinister or vile than the state of Illinois. And there absolutely is no state which is engaging in more unconstitutional trampling of its citizens' rights right now than the state of Illinois. Listen, if you got any more questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information's right down there in the description box. Now, in the meantime, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.